thank you, Paola, also for these remarks that are also the critical ones, criticizing the reasoning. I will not even try to defend the case. I sat on the case, so I prefer not to leave it open to the audience, because I would have to probably, if I had to defend the position, I would have to reveal something that I cannot reveal in the deliberations, you see, so this is something I will refrain from doing. Now, Rein Müllerson, you have
I'm ready. Yeah,
the floor now. Rein is an old friend, we have been together many years in the Human Rights Committee. So.
Thank you, Fausto. And I would like also to thank the organizers of the wonderful conference, which has given me an opportunity to meet many old friends and make some new friends. But I feel there is certain sadness in the air here and a void. And that's it. Nino is not here, and everybody feels that he is still with us. I met Nino maybe some 20 years ago in Florence, and I addressed him, Professor Cassese, and he told me, and I think it is usual, call me simply Nino. And since it was always Nino, wherever we met in London, in The Hague, or elsewhere, and last time we met, maybe it was not accidental, even in Italy, not in Florence, but in Naples. So it is very sad as well to be now here in The Hague without Nino. In my presentation, I would like to comment on the impact of the ICTY on crimes against humanity, on some aspects of it. And the basic reason is that recently I was a member of a commission, international commission, which studied crimes committed or bloody events in southern Kyrgyzstan in 2010. And the report of this International Inquiry Commission, which called KISS or KIK, the Kyrgyz Inquiry Commission, paid tribute to the case law of the ICTY and ICTR as well, and used customary international law, and by doing that used also the case law of the ICTY as evidence of customary norms, to the development of which, of course, the Tribunal has contributed immensely. And about that, maybe a bit at the end of my presentation. First of all, the ICTY has contributed to the clarification of differences and overlaps between the three categories of crimes we are discussing now here. It is well known that one and the same act, actus reus, may be qualified depending on mens rea or the context within which acts were carried out as a war crime, a crime against humanity, or an act of genocide. For example, war crime, for war crimes, the characterization of some acts as being widespread or systematic is an aggravating circumstance, indicated inter alia that such acts are not individual excesses but systemic crimes, and there is a state or other more or less organized authority behind them. At the same time, for crimes against humanity, widespreadness and systematicity are necessary qualifying elements. In the Tadic case, the Tribunal clarified these concepts, indicating that widespreadness refers to the number of victims, while systematicity indicates that a pattern or methodical plan is evident. In the case of genocide, there has to be direct intent to commit an act of genocide. That's to say, to destroy in whole or in part a protected group. While in the case of crimes against humanity, there has to be knowledge that one's behavior constitutes a part of a widespread or systematic violence. And quoted one of the decisions of the ICTY, the perpetrator must knowingly commit crimes against humanity in the sense that he must understand the overall context of his act, that he has an actual or constructive knowledge of the broader context of the attack, meaning that the accused must know that his act is a part of a widespread and systematic attack on a civilian population and pursuant to some sort of policy plan. One of the forms of actus reus of crimes against humanity that is somewhat close to acts of genocide is persecution. As Nino Cassese has written, the distinction between genocide and persecution, as for mens rea, is that the perpetrator of genocide must intend to destroy all or part of a protected group, while the perpetrator of a crime against humanity needn't have such intent, and persecution can be seen in many other forms of inhuman and discriminatory intent other than intent to destroy. The Rome Statute stipulates that an attack against a civilian population is a source of conduct involving the multiple commission of enumerated acts. Nonetheless, a single act also can constitute a crime against humanity if it is a part of a larger attack. The widespread nature of the attack is based upon its scale, the number of people targeted, or the cumulative effect of a series of inhumane acts, or through the specific effect of a single large-scale act. Its systematic nature is inferred from the organized character of the acts committed and from the improbability of their being random in nature. Patterns of crimes, that is, the non-accidental repetition of similar criminal conduct on a regular basis, are a common expression of such systematic occurrence. The ICC statute also includes the requirement that the attack must be committed pursuant to or in furtherance of a state or organizational policy. However, in the jurisprudence of the ICTR and the ICTY, this requirement has been interpreted as not constituting a separate legal element of a crime against humanity, though it is still evidentially relevant in proving the widespread or systematic nature of an attack. In relying upon customary international law approaches to crimes against humanity, the Kyrgyz Inquiry Commission didn't need to take a position on the debates surrounding the approaches to this matter. Instead, in conformity with existing law, it adopted a relatively demanding standard, I am quoting, in order to assess whether a sufficient degree of organizational policy existed in relation to the June 2010 events. That's to say, the Commission considered that certain organization and certain policy of that organization was a necessary element of crimes against humanity. It is clear that such an organization needn't be a state, and in the case before the Kyrgyz Commission, it certainly weren't the central authorities of Kyrgyzstan who organized the attacks under consideration. The protection of civilian population is central to the concept of crimes against humanity. It is from this that the requirement that the widespread and systematic attack be directed against them arises. And civilian population, as the ICTY has established, includes not only people who are not in uniform and have no link to the public authorities, but all people who are hors de combat and thus are not or are no longer taking part in the conflict. A population may be classified as civilian even if it includes non-civilians, provided that civilians comprise the majority. Thus, the expression civilian population must be understood in the broadest sense. Of the enumerated acts listed in the definition of crimes against humanity, the Kyrgyz Inquiry Commission considered that the following crimes were committed during the attacks against what they called Mahalyas Uzbek compounds in southern Kyrgyzstan: murder, rape, other forms of sexual violence, other physical violence, and persecution against an unidentifiable group on ethnic grounds. While the enumerated acts are generally well-known crimes under domestic law, the crime of persecution required further elaboration. Persecution is a crime encompassing a large number of acts, including, amongst other, those of physical, economic, or judicial nature that deprive an individual of the exercise of their fundamental rights. The acts of persecution must be a manifest and flagrant denial for reasons of discrimination of a fundamental right protected by international customary or treaty law, and be at the same degree of seriousness as the acts listed in the definition of crimes against humanity. In this respect, the Kyrgyz Commission considered that many of the acts committed, including the targeted burning of Uzbek property, fall within the definition of persecution. In assessing whether the attack against the Uzbek population in city Osh was widespread or systematic, the Commission followed the methodology established by the ICTY appeals chamber. That is, to first identify the population, which is the object of the attack, and in the light of the means, methods, resources, and result of the attack upon the population, ascertain whether the attack was indeed widespread or systematic. And in doing so, the Commission considered the consequences of the attack upon the targeted population, the number of victims, the nature of the attacks, the possible participation of officials, authorities, or any identifiable pattern of crimes, to determine whether the attack satisfied either or both requirements of widespread or systematic attack. Numerous incidents reported by the Commission showed that the acts of violence targeted Uzbek compounds and the Uzbek individuals, groups, and property contained within them. The targeting of the Uzbek population was at its most simply reflected by the fact that 75% of the people killed and the overwhelming majority of the destroyed property belonged to the Uzbek community. The attacks on the compounds exhibited pattern and order of several days' duration. Attacking crowds unable to penetrate barricades often withdrew, regrouped, and relaunched the attack with the aid of APC armored personnel carriers. This sustained behavior of specific targeting and some kind of discipline and order wouldn't be commensurate with the normal chaotic actions of rioting civilian crowds. Almost all the evidence of sexual violence involved gang rape. Usually rape occurred in front of either male family members or publicly. And the Commission was satisfied that this sexual violence was integral to the widespread and systematic attack on the civilian population. That's to say, it was a part of crimes against humanity. And the Commission, emphasizing that it was not a criminal tribunal, found that, quoting, if the evidence of some acts committed during certain attacks against the compounds in June was proven beyond reasonable doubt in a court of law, those acts would amount to crimes against humanity. In coming to such a conclusion, the Commission used not only customary international law as embodied inter alia in the Rome Statute, but also the case law of the ICTY, and to a lesser extent also the ICTR. The Commission was satisfied that all three physical elements of crimes against humanity were present. There were acts such as murder, rape, or serious injury to body or physical health. They were committed as part of a widespread or systematic attack, and these attacks were directed against civilian population. And of course, what the Commission didn't do, couldn't do, and was not mandated to do, was to study the presence of the subjective element, mens rea, in the behavior of those concrete individuals who committed, organized, or instigated such attacks. This should be the task of the Kyrgyz judicial bodies, which they, so far at least, are failing to implement. The work of the Commission illustrated a problem that is not idiosyncratic for Central Asia only. Victims of the violence, and especially those who backed them, tried to persuade the members of the Commission that they were victims of genocide, and nothing else would satisfy them. The Kyrgyz authorities, on the contrary, were unhappy and even furious that we found prima facie a case for crimes against humanity. The Kyrgyz parliament even passed a resolution asking the executive branch to declare the head of the commission, the Finnish diplomat and politician, Kimmo Kiljunen, persona non grata in Kyrgyzstan. Such an attitude seems to indicate that the concept of genocide is sometimes used too loosely or even abusively, and crimes against humanity are not always considered to be most serious crimes, which they certainly are. And finally, I would like to offer some comments concerning the impact of the ICTY and other international tribunals on the development of customary international law in the domain of war crimes, crimes against humanity, and genocide. Everybody is familiar with the assertion that decisions of international courts and tribunals are binding only for the parties of the case, and they don't serve as precedents. But almost everybody also agrees that in practice they often do exactly that. The matter is that it is often for judicial bodies to look for the state practice and opinio juris and to analyze various acts of behavior and decide whether there is a customary norm and what is its content. As yesterday George Abisab said, they perform the role of midwives. If we may say, there is a trinity. If the mother is state practice, then the father is opinio juris, and midwives are international courts and tribunals. But here a caveat is necessary, I think. The final word still remains with states. States are, of course, bound to implement decisions of international courts and tribunals, whether they agree or disagree with them. But disagreements or agreements are not without legal consequences. If they voice their disagreements, they express their opinion non juris. States that don't express their disagreements may be seen as acquiescing as to the decisions of the tribunals. But if a sufficient number of states voice their disagreements with such decisions, we may indeed say that such decisions don't reflect existing law and were erroneous, though even such decisions will remain legally binding. And finally, Professor Tinstein has written that unfortunately an international court or tribunal may make an explicit finding about the existence of customary international law, and yet there is no escape from the conclusion that the finding is wrong. As an example, he offers the Kupreskish case before the trial chamber of the ICTY, where the chamber found that the belligerent reprisals against civilians prohibited by the first additional protocol were also part and parcel of the customary international law. Joram Tinstein believes that such a pronouncement to be glaringly incompatible with the general practice of states since 1977. I am not going to take any stand on this issue. In any case, it is not, with all due respect for Professor Tinstein or for myself, to decide. What is important is the reaction of states to such judicial pronouncement. Even if considered erroneous by quite a few serious academics, states have the final say. What is important is whether they acquiesce in judgments of international courts and tribunals, protest against them, or otherwise express their approval or disapproval of such judicial pronouncement. In the domain of international humanitarian law, which is heavily value-loaded, differently from, let's say, the maritime delimitation law, states, even if they disagree with what, say, the ICTY decides, prefer to remain often silent, keep their views to themselves. This means that in adequate circumstances, international criminal tribunals can push the envelope and play a more creative role than other international judicial bodies. And the ICTY has used this opportunity creatively. Thank you.
Well, sorry for being thank you, Rein. Well, this shows the contribution of the tribunal to the law, also used by other bodies. And I started with Kupreskic and you ended with Kupreskic on different tones, but we remain in this ambit. Now, Steve, you have the floor for your presentation.
Thank you very much, Judge Pocar. And I'd also like to thank the organizers and President Robinson for inviting me here. I want to begin by associating the United Nations with the comments that Judge Pocar made at the beginning about Nino Cassese. The United Nations called upon Nino on many occasions throughout his career, and he always responded. And his contribution to international law was immense, as we all know, and was greatly valued by many secretaries general and legal councils, and he will be missed. In my speaking personally for a moment, I knew him only as a president. When I first knew him, he was the president of this tribunal, and I was working at the American Embassy as the legal counselor there. And then when I came to the United Nations last year, I had the great pleasure of working with him again in his capacity as the president of the Special Tribunal for Lebanon. So he will be missed. Now, when conflict broke out in the Balkans in the early 1990s, and shortly thereafter in Rwanda, I don't think that anyone here, or anyone in a larger audience than this one, could have imagined what has since happened here in The Hague and in Arusha, that an international court was created and has punished the guilty, has given voice to the victims, and has helped to establish the historic truth of the horrors that took place in the former Yugoslavia and in Rwanda. I think it follows from that no one would have predicted today's extensive architecture of international criminal justice with the ad hoc international and hybrid or mixed tribunals, the International Criminal Court, These developments over the past 18 years have heralded a new era of accountability for individuals committing serious violations of international criminal law. And importantly, from my perspective, and for the purposes of my brief presentation this afternoon, many of these developments, many of the aspects of this extensive architecture have been adopted on the basis of mandates supported by the international community acting through the United Nations. It turns out, I think, that the establishment of the ICTY was actually a watershed event in the life of the United Nations. And I thought I might speak briefly this afternoon about some of the effects that I think this tribunal has had on the broader United Nations and the work there. I'm going to, in talking about the United Nations, of course, we need to have in mind both the political organs of the United Nations, the Security Council and the General Assembly, and also separately the Secretariat and the manner in which the Secretariat goes about its business. And so I'm going to make a few observations about actions both by the political bodies on the one hand and then by the Secretariat on the other that in some way I think reflect the legacy of this tribunal. Now, with respect to the political organs, and in particular the Security Council, although not exclusively, because as you know, the General Assembly had a leading role in the creation of the extraordinary chambers in the courts of Cambodia. But in the case of the political organs, perhaps the most obvious effect that the ICTY's work has had can be seen in the development of later international courts and tribunals. The lawyers in the office in which I now work, who had the lead in drafting the statute of this tribunal, had very little to go on in terms of practice for the 50 years after the Nuremberg and Tokyo trials. During the Cold War period, there was very little practice in the field of international criminal justice. As Judge Pocar noted, there had been some conventional law during that period, but practice, no. Now, it's clear, I think, that the Office of Legal Affairs did a pretty good job with the statute of the ICTY, in the sense that I think the statute of the ICTY has become the standard of reference, if you will, by which then other international tribunals from which the other international tribunals have been adopted. And we have seen already with the Rwanda statute, there was a broadening of what the jurisdictional aspects and the nature of some of the crimes, of course also taking into account the different factual situation of the events in Rwanda. But then we've seen subsequently, as each of the additional hybrid courts and other bodies have been developed, there have continued to be developments, and to a large extent, I think, reflecting some of the jurisprudence here, but also taking into account the specific factual situations of those particular ad hoc bodies. And, for example, the jurisdiction of the Special Court for Sierra Leone included for the first time the international crimes of attacks on peacekeepers and the conscription of child soldiers. And one can see, if one tracks carefully the developments, similar jurisprudential developments in those statutes. Now, of course, these statutes generally, as I say, have been adopted by political bodies, mostly the Security Council. And so we see through the political organs of the United Nations a kind of indirect recognition of the jurisprudence of this court. This tendency toward the development of the body of international criminal law, I suppose, reached its culmination with the statute of the ICC, which I think so clearly benefits from the lessons learned from the ICTY. in particular with respect to the definition of the crimes within its jurisdiction. Now, the ICC is not a UN entity in the sense that this tribunal and some other tribunals are, but of course the relationship between the ICC and the United Nations is very strong. I think it can be suggested that the establishment of the ICTY promoted what could be seen as an emerging global culture of accountability. When the Office of Legal Affairs was drafting the ICTY statute, there were very few experts in international criminal law and fewer actual practitioners. I suppose Judge Cassese was one of them at that time. Of course, since the ICTY, there's been a tremendous growth in the practice and the study of the discipline of international criminal law, and it has a new place in the public consciousness. And I think this culture of accountability has touched the member states of the United Nations, and also it's affected the United Nations itself. With respect to the General Assembly, I wanted to make brief reference to the development of the responsibility to protect doctrine, which I think can also be viewed in a way as an outgrowth of this culture of accountability that I've spoken of. Now, for the United Nations, the responsibility to protect found its expression in the 2005 World Summit. And there, as I'm sure many of you realize, the heads of state and government who were present affirmed that each individual state has the responsibility to protect its populations from genocide, war crimes, ethnic cleansing, and crimes against humanity, those 4 categories of crimes, and that the international community, through the United Nations, also has the responsibility to help protect populations from those same 4 crimes. And I think it's clear that the jurisprudence of the ICTY was critical in defining and developing the crimes that underpin the General Assembly's concept of responsibility to protect, and in raising consciousness of the international community with respect to this group of crimes. Now, in the context of the responsibility to protect, the United Nations works on the basis of 3 pillars of activity which were set out in that World Summit declaration. First, that it's the obligation of states, the responsibility of states to protect their own populations. Secondly, that there should be international assistance and capacity building to assist states to protect their populations. And third, that there should be a timely and decisive response by the international community where states are not able or willing to protect their populations. Now, I don't think this is the place for a substantive discussion of responsibility to protect. We could probably have a separate panel on that. But I do think it's worthwhile to note in this context, because it does represent a political acknowledgement by the international community that sovereignty entails responsibility, and that the international community has a responsibility to assist states to protect their populations from genocide, crimes against humanity, war crimes, and ethnic cleansing. And again, I think the key role of the ICTY in defining these crimes and in shaping the debate about these crimes demonstrated the need for the international community to develop a concept that would permit action to be taken against them. Now, those are the instances that I wanted to mention of action by the political organs of the United Nations, the creation of subsequent tribunals, the development of the doctrine of responsibility to protect. Now I'm going to deal very briefly with a few respects in which within the Secretariat itself, the development of the ICTY has, I think, contributed to the manner in which the Secretariat does its work in a way that responds to the legacy of this tribunal. One very concrete effect of the global culture of accountability has been the appointment of special advisors and representatives of the Secretary General on themes that have featured largely in the jurisprudence of the ICTY and the other tribunals. Thus, for example, in 2004, we had the appointment of the Secretary General's Special Advisor to prevent genocide and mass atrocities. In 2006, the Special Representative for Children in Armed Conflict. In 2007, the Special Advisor on the Responsibility to Protect. And in 2010, the Special Representative on Sexual Violence in Conflict. Now, the fact that these offices are now standing offices within the Secretariat has allowed the United Nations to take a more active approach in seeking to prevent genocide, war crimes, and crimes against humanity. The effectiveness of the individuals serving in these roles has been promoted by the development of the International Criminal Court and by the jurisprudence of this tribunal and the Rwanda Tribunal. For example, in decoupling crimes against humanity from armed conflict and from defining and calling attention to crimes of a sexual nature. So based on these developments, the United Nations and the international community are more empowered than they were previously in being able to prevent and combat these crimes by means of early warning systems and, importantly, by raising the threat of prosecution for these crimes as a deterrent to the commission of the crimes. Now, the culture of accountability that I've been speaking about that resulted from the ICTY's work has also had a concrete effect on the UN's peacekeeping activities. Currently, in the United Nations, there are over 80,000 troops, blue-helmeted troops, in 16 different peacekeeping operations around the world. And they're serving under increasingly complex and multidimensional mandates, which increasingly include the authorization to use force under Chapter 7 of the Charter, which, as you know, was not true of the initial group of peacekeeping missions. A very important development in the Security Council is that these missions increasingly are mandated to protect civilians under imminent threat of violence. And we've just heard how the protection of civilians is related, really, to the crimes against humanity. They're parallel concepts. One is a more active set of steps to prevent the other. Now, these protection of civilian mandates have presented a lot of challenges for the United Nations. It's a very difficult mandate to satisfy. And they're somewhat restricted in scope in that they're subject to the availability of resources and geographically limited to areas where peacekeepers are deployed. But nonetheless, they do provide a crucial means to prevent violent attacks on civilian populations. Another way in which the United Nations has addressed accountability is in what's called the Human Rights Due Diligence Policy. And this policy is a means of ensuring that the United Nations itself is never perceived to be connected to or complicit in the commission of the crimes that we've been discussing. The genesis of this due diligence policy was the UN response to allegations in 2009 that some members of the Congolese army, the FARDC, who were being provided logistical support by the UN's peacekeeping operation in the Democratic Republic of the Congo, MONUC, that some members of the FARDC were looting, killing, and raping the very population that they were supposed to be protecting. So this presented a difficult situation for the United Nations. How to carry out its mandate from the Security Council in the DRC without supporting in any way Congolese soldiers who might abuse human rights. This led to the development of a policy in the Secretariat to prevent any perception of association by MONUC, the peacekeeping operation, with these violations by the FARDC. The policy specified that MONUC would not participate in or support operations with FARDC units if there were substantial grounds to believe that there was a real risk that such units would violate international humanitarian law, international human rights law, or refugee law in the course of their operations. This policy developed by the Secretariat was later endorsed by the Security Council, which in Resolution 1906 of 2009 called upon MONUC to intercede with the FARDC command if elements of an FARDC unit receiving MONUC's support were suspected of having committed grave violations of such laws. And the resolution continued that if the situation persists, MONUC should withdraw support from these FARDC units. This policy, developed initially only in the context of MONUC, has now been further developed and clarified and applies across the board where the United Nations is considering providing some kind of support to non-UN security forces. And this reflects, I think, the culture of accountability that we've been discussing, and it shows that it applies to the United Nations as well as to member states. The final point I'm going to address is the amnesty policy of the United Nations. Now, the jurisprudence of the ICTY and the global culture of accountability have also affected the position of the United Nations with respect to peacemaking, namely with respect to UN assistance to peace negotiations, and in particular in connection with the issue of amnesties. In 2005, the General Assembly adopted the document Basic Principles and Guidelines on the Right to a Remedy and Reparation for Victims of Gross Violations of International Human Rights Law and Serious Violations of International Humanitarian Law. In 2006, the Security Council similarly addressed the issue in its Resolution 1674. These policies reflect the agreement of the member states with the long-standing position of the UN human rights bodies and experts, as summarized by the Secretary General in his 2004 report on the rule of law and transitional justice in conflict and post-conflict societies, that United Nations endorsed peace agreements can never promise amnesties for genocide, war crimes, crimes against humanity, or gross violations of human rights. In its 2009 guidebook for practitioners dealing with amnesties in post-conflict states, the Office of the High Commissioner for Human Rights noted that peace agreements secured at the price of amnesty for atrocious crimes may not secure a peace that is just or lasting. Accordingly, the United Nations, through the Department of Political Affairs, directs all of its officials, including peace negotiators and field office staff, that they must never condone or support amnesties that would prevent prosecution for the crimes that we're discussing today, including gender crimes, as doing so would violate the right to an effective remedy for violations of human rights as enshrined in Article 8 of the Universal Declaration of Human Rights. Now, the UN's policies on amnesties has its roots in and takes support from the ICTY's 1998 decision in the Ferengise case. A trial chamber of the ICTY held in that case that a domestic amnesty covering crimes such as torture that are prohibited by Jus Cogens norms would not be accorded international legal recognition. The trial chamber in that case drew up support from a 1994 statement by the UN Human Rights Committee that amnesties covering torture are generally incompatible with the duty of states to investigate such acts, to guarantee freedom from such acts within their jurisdiction, and to ensure that they do not occur in the future. Now, the statute of the Special Court for Sierra Leone specifically provides that amnesty cannot be a bar to prosecution for the crimes within the SESL's jurisdiction. And in examining that provision of the Special Court statute, the Appeals Chamber drew support from the ICTY's jurisdiction and stated that it stands to reason that a state cannot sweep such crimes into oblivion and forgetfulness, which other states have jurisdiction to prosecute, by reason of the fact that the obligation to protect human dignity is a peremptory norm and has assumed the nature of obligation erga omnes. So, we conclude on the point of amnesties, and I think the significance of that for our purposes is that amnesties, that by preventing amnesties that would include these core crimes, that we permit accountability for those, we prevent impunity. And I think in the broader sense that the great legacy of this tribunal is that I think it has made The Hague a symbol of a world which is refusing now, increasingly, to countenance impunity. And I think this tribunal has made a great contribution to that, the development of that principle. Thank you.
Thank you, Steve. This has been a very interesting aspect of the legacy. It is how the case law, the definition, the clarification of the crimes that has been done by the ICTY and other courts, international courts, indeed can serve as the point of reference for international obligations as set forth in other international instruments, and in particular how the UN has indeed made reference to this in shaping these obligations of other states, of states, which is a very important contribution because it puts also in light the that repression of crimes is not the only approach to crimes. Actually, is the approach of the courts, but in fact, the prevention of crimes is the main obligation for the international community, and indeed is and should be the policy of the United Nations in particular. Well, we don't have much time for debate, but we have time to take some questions. I will pass the floor to the audience. If there are questions to put to our panelists, please, this is the moment, and this is the last moment possible during this conference. So don't miss the opportunity if you have any question to raise. Yes, just from the Bengal.
Maybe a question to you, Mr. Chairman. I'm not sure I understood the purpose of what you were proposing to turn torture and gender crimes into autonomous crimes. Would that then mean that the chapeau requirements that we have for the classical crimes, like war crimes, crimes against humanity, genocide, would disappear? And what would then be the difference from national crimes? And my second question is to Paola. I was wondering what she makes of the distinction between torture as a crime against humanity and torture as a war crime in the ICC statute. Does it make sense according to you? Thank you.
Well, I can answer very quickly. I mean, I don't have any particular purpose. I was simply noticing a trend in that direction and was wondering whether the case law of the Tribunal left the question to my colleagues, whether the case law was going in that direction or could give a support to this trend in singling out some crimes, some types of crime, as it has been with genocide, which was under the umbrella of crimes against humanity in Nuremberg, irrespective of the denomination of the crime, of course, which was not yet been adopted, but the concept, came under crimes against humanity, and then there was a decision to single it out and making it a separate, independent type of crime, and indeed almost a category of crimes, because, as we know, genocide is not one individual act, it's a number of acts, a number of crimes, in fact, that has been selected. So I noticed, particularly in legal literature, a trend to single out torture, and was wondering myself what will be at the end the difference in a way. Now, Paola has identified it essentially in the perpetrator, in the qualification of a perpetrator, the difference from ordinary crimes, because there would be, it would be an international crime when it's a public official. It would not when it's not a public official. If I got exactly her position. So this could be, but it wouldn't need to be systematic, wouldn't be to be widespread or linked to the war when it is for a war crime. So this would be the, but Paola, you may
yes.
Answer your question.
Yeah, my question. Now I don't have with me the elements of crimes, but I guess that you refer to the purposive element where it is requested for war crimes, although in general terms, and it's not requested at all for crimes against humanity. I think that the distinction does not make sense from the point of view of the logic, as I was mentioned before, and I don't think it would necessarily correspond to customary international law, because I've ask myself for which reason for a war crime, once you drop the state official requirement, you will need a very general purpose, and for crimes against humanity, that does not make any. I think the only answer is perhaps because when it comes to war crimes, which are usually committed by soldiers and not by necessity, but generally, of course, also for private individuals, but war crimes is the typical category. States drafting the elements of crimes wanted to be more restrictive, simply like that. But it does not make sense to me. I hope it does not make sense to you too. Okay.
Yes, George?
Thank you. I have a very short question. It's about the principle of legality. Can we really invent new crimes? We have three categories. We cannot go out of them. In my short, separate opinion in Tadic, I said that after the Second World War, we were trying to grasp these horrors but from different angles, and we had a lot of overlap. I understand very well that we try to rationalize the thing and make them fall into separate categories, but we cannot go beyond the categories we have and say this has become a crime in itself. I think it creates a problem. It could be perhaps try to say that through custom, etc., but for the tribunal as such, it has its statute and it is limited by it. Its jurisdiction, ratione materia, is limited by it. I know it's just a question, and I don't know who wants to answer it, if anybody.
Yeah. Of course, what George said, for the ICTY it remains. The ICTY is bound by the statute, and torture is part of either war crimes, crimes against humanity, or even genocide. So, but what Fausto said is for the future, maybe whether the jurisprudence of the ICTY has contributed to this development, which would separate torture or maybe gender crimes from crimes against humanity and war crimes. I don't think personally so. And I tend to agree with Paola that torture as a human, the prohibition of torture as a human rights norm. Yes, it is understandable that it is addressed to states, and states shouldn't torture, shouldn't condone torture, and they have to punish those who torture. Therefore, there is this element of state participation, or either actively or passively. And if we take private torture, then in that case, in order to become an international crime, a separate crime, then it has to be kind of widespread and systematic. And I don't see any need for that be a special crime, separate crime. It is a part of crimes against humanity, if it is such, or in the context of an armed conflict, it's a part of war crimes.
There is no doubt that it is so today. But of course, state practice is unpredictable. And nothing could prevent the state practice from orienting itself to say that a particular crime, irrespective of any condition, is so heinous, so egregious, that it becomes of international concern. It becomes an international crime. After all, the notion itself of crimes against humanity was based on that. Certain conditions were set up. It must be widespread, it must be systematic, but these were conditions that were put to limit the notion at a certain moment. But what was the initial concern of the international community was that certain crimes could not be accepted internationally, even if committed internally. Now, nothing would prevent the practice from going that direction and say torture is so a crime that is so unacceptable that wherever it is committed, even by private people, cannot be accepted. It's not the case nowadays. In human rights, when the Human Rights Committee, because it was the first body to say that, put an obligation of states to prevent and repress torture committed by private individuals, didn't have in mind the private crime made individually, as it was mentioned, the husband with the wife or vice versa. Had in mind, for instance, that in a school, ill treatment could be committed, and that if that is a private school, should not be tolerated. The state would have an obligation to prevent it, or a hospital where medical experiments are carried out. These were the situation that primarily moved the Human Rights Committee to insert that sentence in the general comment on Article 7 of the Covenant, which was very much disputed because it went against or beyond the Convention on Torture. And from that position of the Human Rights Committee, the Kunaraj case started from there, assessing the practice. But there would be nothing strange if in a given case the torture itself were taken up by the international community, by practice of states, and criminalized internationally, irrespective of any of these conditions, because what I said, in schools and hospitals, you may always find the systematic or the widespread element in. So it's relatively easy. But state practices can develop. So has the ICTY contributed in a way to a trend in that direction? Is still open, of course, the question, and I'm not giving an answer yes or no, but certainly defining the elements, defining may eventually lead to a certain position. For instance, in a resolution of the Security Council on responsibility to protect, one could expand the notion of torture. Why not? Well, it's easier, of course, and safer for the General Assembly to rely on case law, for instance. But if that case law, when you apply that resolution, allows for some margin, well, I do not know. I leave the question open for the time being. It's just a possible trend, actually.